Good afternoon, class. So this will be a continuation of our lecture on Chapter 4, which talks about the obligations of the vendor or the seller. So be warned that this will be a very long lecture, probably around almost 50 provisions. So anyway, let's begin with Section 2, which talks about delivery of the thing sold. So in 1497, it defines yung delivery, tradition, or in Latin, traditio. Again, remember your Latin terms. So, tradition or delivery is a mode of acquiring ownership. So, remember, if you enter into a contract of sale, ownership is not yet acquired by the buyer because, again, a contract of sale is not a mode of acquiring ownership. But, remember, delivery is a mode of acquiring ownership. So, dun ka lang magkakaroon ng ownership if the object is delivered to you by the seller and ownership is transferred by the seller. So remember here, the object is placed in the control and possession of the vendee who accepts the sale. So obviously, in all the different modes of effecting delivery, it is the real intention of the parties to deliver on the part of the vendor and to accept on the part of the vendee, which gives legal effect to the act. So remember, class, not only must there be delivery, there must be an intention to effect delivery, transfer ownership. Kasi pwede mong i-deliver yung object without necessarily transferring ownership to the buyer. So here, class, delivery, dapat magkaroon siya ng intention to deliver and also intention to transfer ownership. Kung wala yung intention, remember, there is no tradition. So, the rules regarding actual delivery is made when the thing sold is placed in the control and possession of the vendee or his agent. So, remember, physical delivery of the thing usually done by passing of a movable from hand to hand. So, mag-abutan na lang kayo katulad ng sinabi ko kanina sa Section 1. What else? Again, delivery is not always essential to the passing of title. So the parties to the contract may agree that ownership will not yet be transferred to the buyer and they may agree on the conditions so that the ownership will transfer to the buyer. So pwedeng magkaroon ng stipulation that ownership will pass to the vendee only after payment of the full payment of the purchase price as in yung pactum reservati dominii. So anyway, rules regarding constructive delivery naman, this is equivalent to actual delivery. So, constructive delivery, general term, comprehending all those acts which, although it does not confer physical possession of the thing, it is equivalent by interpretation of law to be acts of real delivery. So, yun ang tandaan natin. Constructive delivery is equivalent to actual delivery. Although again, the parties may stipulate to the contrary that the ownership will pass only after full payment of the purchase price pursuant to yung contractual reservation of ownership or yung pactum reservati domini. So what else? Requisites of constructive delivery. Seller must have control of the thing. Otherwise, how can he put another person in control of the thing? What else? Buyer must be put under control. And number 3, there must be intention to deliver thing for purposes of ownership. So, ang tandaan nyo lang sa constructive delivery, a seller cannot deliver constructively if he cannot deliver actually, even if he wants to. So, kung hindi niya ma-perform yung actual delivery kahit gusto niya, kahit possible, hindi siya pwedeng mag-deliver constructively. So, in number 1, if the seller has no actual possession, he cannot transfer ownership by actual delivery. So, transferee should have control. But control in case the object is in the hands of a third person, remember, control cannot be had because it is in the possession of another person. What else? A buyer must be put under control. Keyword here is control, not simply possession. Kailangan makokontrol ng buyer yung object that is delivered constructively. What else? Intention to deliver the thing for purposes of ownership. Again, pagka deliver mo yung object for purposes of inspection, examination, etc., etc., that is not delivery as defined by law. Because remember, yung deliver here must be for the intention of transferring ownership. 1498 talks about kinds of delivery. Yung 1498 talks about yung legal formalities or execution of a public instrument or a document. So remember, this applies to real and personal property because the law does not extinguish. The manner of delivery here is symbolic. So yun lang sinasabi ko kanina, deed of sale, etc., etc. So yung public instrument, we have already studied this one. Ito yung mga instrument which have been notarized by a notary public. This serves as parang notice to the entire world pagka public kasi yung instrument. So what else? Symbolical tradition or traditio symbolica also in 1498. So parties make use of a symbol or token to represent the thing, delivery of the key to the place where the movable sold is being kept. Also delivery of keys to a warehouse, etc., etc. Traditio longa manu in 1499, so applies to movable property. So movable lamang. So delivery here is by mere consent or agreement. It will also include when the seller points to the thing, and after pointing to the thing, the buyer is put in at the control or disposal of the thing. So yung longa manu, remember, by agreement. Sa'yo na to. Kahit na hindi i-deliver yung, halimbawa, kalabaw, yan. Sa'yo na yung kalabaw na yan. Tinuro lang yung kalabaw. So, here, the buyer accepts delivery. So, remember here na meron ng traditio longa manu. So, here, this is qualified by the phrase, if the thing sold cannot be transferred to the possession of the vendee at the time of sale. So, yung kalabaw, hindi pa mai-transfer sa vendee, possession niya, let us say, wala namang sasakyan yung vendee para iuwi yung kalabaw, etc., etc. So, basta nagkaroon na ng agreement na sa kanya na yung kalabaw na yan, there is, tapos tinuro pa nga ng seller, there is already delivery by traditio longa manu. Traditio brevi manu, also defined in 1499, again applies to movable property. So buyer has the possession of the object by another title even before bilhin niya. So yung tenant buys a car, buys a house, nagngungupahan lang kayo dati, tapos bigla binili nyo na yung inuupahan nyo. Remember here, the status of possession changes from mere lessee to the owner of the object. So remember here that delivery is done by fiction of law. In case naman of traditio constitutum possessorium, which is the opposite of brevi manu, which is defined in 1500, remember, vendor continues in a different capacity, not anymore the owner, but in some other capacity. Again, here, class, the basis of delivery is consent. Yung binigay ko yatang example dito kanina, siya ang may-ari ng bahay, tapos bigla na papunta na siya ng abroad, etc. So, binenta na niya na yung bahay niya. Habang hindi pa siya umaalis, inuupahan muna niya doon sa bagong may-ari ng bahay. Here, he is still in possession. The seller continues in possession, not anymore as owner, but as lessee of the house. The basis of delivery is consent. In 1501, ba't nagmamadali ako? Kasi gusto kong iksaan yung video, so nagmamadali rin ako, etc., etc. In 1501, quasi traditio, again, delivery of incorporeal things or rights, kinds of traditio, public instrument. So again, deed of sale to sell yung shares of stock, patent, etc., etc. What else? Royalties, etc. Placing titles of ownership in the possession of the vendee, like you put into the hands of the vendee the shares of the certificate of stock, which is different from the share of stock. Yung certificate of stock, iyon na yung written evidence of ownership of a stock in a corporation. Now, allowing the vendee to use his rights as new owner with the consent of the vendor, buyer will vote in the election doon sa corporation kung saan binili niya yung stocks from the seller. Now, remember here, this is subject to different rules kasi hindi naman basta-bastang makakaboto yung buyer. So, probably proxy muna. Yan. authorization from the seller na siya yung magbo-vote ng mga shares. But remember here, sa mga corporations, they will not allow you to vote if you are not the stockholder on record. So, yung transfer must be recorded also in the stock and transfer book of the corporation. So, yun, quasi-delivery, quasi-tradisyo. So, in 1502, this will talk about a contract of sale or return. So, this is a sale subject to a resolutory condition. So, again, a resolutory condition has been defined when we studied Chapter 3, Section 1 of the Law on Obligations. So, anyway, sa contract of sale on sale or return, the sale is dependent upon the discretion of the buyer. So, property is sold to the buyer, the property is delivered to the buyer, and the buyer will become the owner of the property. But remember, the buyer has the option to return the object to the seller instead of paying the price. So, binigay muna sa buyer. So, nasa buyer na yung object, dineliver sa kanya, and he will become the owner of the object. But remember, meron siyang option na ibalik yung object later on for whatever reason. So, remember, merong option yung buyer. Pwede niyang bilhin, babayaran niya yung price, or pwede niyang ibalik. So, remember, the options, whatever may be chosen, rests entirely on the buyer. So, wala din siyang pakialam dun sa quality ng goods. Basta ayaw niya, pwede niyang ibalik later on. So, remember, buyer will revest ownership in the seller by returning or tendering the goods within the time fixed in the contract. Or, kung wala namang time na nakalagay dun sa contract, within a reasonable time. If not returned, remember that the sale will become an absolute sale and the buyer is liable to pay the price. So obviously here, seller cannot prevent yung the revesting of title by refusing to accept delivery or return of the property. So ayaw ng buyer, for whatever reason ayaw ng buyer, tapos ayaw nang tanggapin ng seller, hindi rin pwede yon. So, bawal i-refuse ng seller yung return sa property. So, here, remember, title passes to the buyer. So, obviously, the buyer will be liable for loss or destruction of the property before it is returned to the seller. So, nasa kanya yung risk of loss. Now, if this is destroyed, while in the possession of the buyer is still liable to pay the price. So, obviously, if yung buyer materially abuses yung object, he has no right to return. Also, what about if hindi naman niya inabuse yung object, but the object deteriorates without the fault of the buyer? Siyempre, buyer can still return provided he returns within the period fixed in the contract or within a reasonable time. So, let us take, for example, a seller delivers to buyer a cellphone, ganyan na lang. So, the sale is on sale or return. So, remember, buyer will become the owner of the cell phone. But obviously, because this is sale or return, the buyer may revest yung or return ownership doon sa seller by returning yung cellphone or tendering the cellphone to him within the time fixed in the contract. So, let us say, sa'yo na muna to, dineliver sa buyer 2 weeks. Kung gusto mo siya, bayaran mo siya in 2 weeks or return within 2 weeks kung hindi mo siya gusto. So, anyway, the buyer should return within the time fixed or if no time has been fixed within a reasonable time. What if dun sa cellphone nung trinay ni buyer, di ba, remember, ownership has been vested to the buyer. Now, nung trinay ng buyer, wala namang mali dun sa cellphone, maganda, type na type nga niya. Question, can the buyer return this cellphone? Kung type na type naman niya, there's nothing wrong with the cellphone. Remember, class, buyer can still return if he finds nothing wrong with the cellphone. Kasi nga, ito ay with this contract rests entirely on the buyer without reference to quality. Kahit nga nagustuhan niya, kung ayaw naman niyang bayaran, kung gusto naman niyang ibalik, wala tayong magagawa. Walang magagawa yung seller. Now, what if the buyer does not return yung cellphone on time? Remember, class, the sale will be considered as an absolute sale. Seller can recover the price. Obviously, buyer has to pay the price. So, how about if yung cellphone, while in the possession of the buyer within the time fixed, hindi pa naman hindi pa naman deadline, but let us say the cellphone is destroyed by a fortuitous event, nalaglag sa kumunoy, tinamaan ng kidlat, etc. So remember here, class, that the buyer bears the risk of loss and the buyer still has to pay the price of the cellphone. Now, what about ano ba yan? What about sale on trial or approval? So here in sale on trial or approval, the buyer will become, this is a sale subject to a suspensive condition. So the buyer may become the owner of the object under conditions specified in the law. Otherwise, the seller is still the owner. So this is dependent on the quality of goods. So kung nagustuhan ng buyer, remember, yun yung suspensive condition. So remember, malilipat na sa kanya yung ownership noong goods after he has paid yung price. Yan. Kung na-approve na yung goods, the sale will become absolute. So this is a contract, sabi nga, in the nature of an option to purchase if the goods are satisfactory. So yung approval is necessary. Ito yung suspensive condition. This is a condition precedent. Meaning, kung walang approval ng buyer, hindi mapaperfect yung contract of sale. So anyway, title will remain with the seller until the sale has become absolute. Paano nagiging absolute yung sale? If the buyer approves of the goods. Now, kung if the buyer fails to comply with the express or implied conditions of the contract, like yung mga conditions na yan is kung hindi niya gusto or he's not satisfied with the quality, he should give a notice of dissatisfaction or pwedeng ibalik niya yung goods or adopt any other or yun nga, ibalik na lang niya yung goods. So yun ang, remember, sale on trial or approval. So buyer must give the goods a trial except if it is evident na hindi talaga ito makakapag-perform ng work that is intended. What else? Period within which the buyer must signify his acceptance will start only when all the parts essential for the operation of the object has been delivered. Also, in sale on trial or approval, a third person may signify approval or satisfaction. Pwede, it can be stipulated by the parties na third person will signify whether or not in short, third person na magta-try, hindi yung buyer. But this provision is valid, but third person must be in good faith. So obviously, if the refusal to accept is not justified, the seller may still sue. So anyway, what you have to remember on sa sale on trial or approval, kailangan ibalik yung object within the time allotted or within a reasonable time. Now, or magbigay ng notice of dissatisfaction yung buyer doon sa seller. The buyer here is actually would-be buyer and the seller is would-be seller. Kasi hindi pa naman na-perfect yung contract dahil it is subject to a condition that is suspensive. Sorry, natawa ako, class. So anyway, now if there is failure to return, failure to give a notice of dissatisfaction, or there are other acts adopting yung transaction when the buyer, yung buyer wala pa naman siyang sinisignify na satisfied siya sa goods pero binenta na niya sa ibang tao. This is, remember, perfection noong sale on trial or approval, in which case it will become an absolute sale. So anyway, please take note of the differences between a sale or return and sale on trial or approval. What else? 1503 will talk about delivery to the carrier. So please take note of the definition of a bill of lading. So a bill of lading is an instrument in writing signed by a carrier or his agent describing the freight so as to identify it, stating the name of the consignor, terms of the contract of carriage, and also agreeing or directing that the freight be delivered to the order or assigns of a specified person at a specified place. So, pagka nagpadala kayo sa LBC or sa JRS or whatsoever, remember, yung resibo na binibigay nila can be considered as a bill of lading. Now, also take note of the term bill of exchange. Yung bill of exchange naman, usually pag-aaralan nyo dapat ito sana sa negotiable instruments. Kaso lang wala na yung negotiable instrument as a subject sa board exam. So tinanggal na rin yung subject na yun as a whole. Anyway, bill of exchange is an unconditional order in writing addressed to one person, by one person to another, signed by the person giving it, requiring the person to whom it is addressed to pay on demand or at a fixed or determinable future time as sum certain in money to order or to a bearer. So, sa isang bill of exchange, remember, meron tayong tinatawag na drawer, meron tayong tinatawag na drawee, at meron tayong tinatawag na payee. So, yung payee is the person who will be paid under the instrument. So, the drawer is the person who will give the order to the drawee para bayaran ng drawee yung payee. Now, remember also that yung drawee is the person who is ordered by the drawer to pay yung payee. So, siya yung binibigyan ng order, yung drawee. Yung drawer is the person who gives the order for the drawee to pay. So, anyway, ito ang itsura ng bill of lading. Nakita ko lang ito sa internet. So, it describes yung goods. So, lalagyan nila yung description, lalagay nila kung ilan, lalagay nila yung mode of payment. So, anyway, this bill of lading is usually issued to the seller. Now, yung seller naman, para ma-claim yung goods ng buyer, dapat niyang ibigay doon sa buyer yung bill of lading. So, anyway, this bill of lading is non-negotiable. But bills of lading, pwede rin naman siyang maging negotiable. So, pwedeng i-endorse ng seller or ay ng buyer to other persons. So, pagka in-endorse ng buyer to other persons, sila na yung magkiklaim from the carrier. So, anyway, also take note of yung bills of exchange. So, ito usually ang itsura ng bills of ng isang bill of exchange. So, this is dated April 13, 2021. So, here, remember, pay to the order of P the amount of 500 pesos. So, here, yung nagbigay ng order para bayaran si P. P here is the payee. So, siya yung babayaran ng 500 pesos. Ang nagbigay ng order para bayaran itong si P ng 500 ay itong si R. So, R is the drawer. And this is addressed to E. So, E is the drawee. So, pagka itong si P, who is the payee, presents this instrument to E, E has to pay P, yung amount na nakalagay doon sa bill of exchange. So, here, remember, si E ang magbabayad kay P. Now, this is an order instrument, meaning this is payable to the order of P or to P or order. So, anyway, si P ang babayaran or kung sino man ang in-order niya na babayaran nung under the instrument. So, let us say, class, itong si P, present niya itong instrument na to kay E, si E, babayaran niya si P. Pero itong si P naman, pwede niyang i-negotiate yung instrument na to. Because bills of exchange are negotiable instruments. So, itong si P, para ma-negotiate niya to, kailangan niyang i-endorse and i-deliver. So, yung endorsement, ito yung ililipat, parang ilipat mo yung instrument sa madaling sabi. So, anyway, itong si P, sabi niya, dun sa likod ng instrument, usually yung mga endorsements sa kalagay sa likod, sabi ni P sa likod, to X. So, si X yung endorsee. Tapos, signed P, pinirma niya. So, yung instrument, besides endorsing it to X, kailangan ding ibigay ni P yung instrument kay X. So, P has to deliver the instrument to X. So, ngayon, dahil si X ang endorsee, si X na ngayon ang magpe-present kay E nung instrument. So, pagka present ni X yung instrument kay E, kailangan bayaran ni E si X. So, si E can further endorse the instrument later on. So, to Y, signed X, basta pirmahan lang niya. Tapos, ilagay lang niya kung sino ang kanyang endorsee. Now, also a bill of exchange may be a bearer instrument. Ito ay bearer instrument kasi anybody who is in possession of this instrument will be paid by the drawee. So, hindi na kailangan ng endorsement dito. To negotiate a bearer instruments, you simply need to deliver it to the bearer. So, whoever holds this instrument and then presents it to E must pay yung holder ng instrument na yon. So, the bearer here is the payee, R is the drawer. Siya yung nagbibigay ng order kay E na bayaran niya yung person who bears this note. So, E is obviously the drawee. So, yun ang mga terminologies na kailangan yung tandaan. Anyway, hindi na natin masyadong pag-aaralan yan kasi wala nang negotiable instruments. So, the rules regarding delivery in 1503 will relate only to specific goods. So, remember, the general rule, ownership in the goods will pass to the buyer upon delivery to the carrier. So, pagka deliver na sa carrier yung goods, ownership will pass to the buyer. However, class there are exceptions. If there is a contrary intention provided in the contract, so this is provided for under 1503 paragraph 1. In the cases provided in the second and third paragraph also of 1503, which we will discuss later on. And number 3, in cases provided in the first, second, and third paragraphs of 1523. In your book, parang medyo nagkapalit-palit ito. So, please take note of that. So, anyway, the exceptions. Here, remember sa exceptions, the seller is still the owner even if the goods are already delivered. So, anyway, if that is expressly stipulated, common sense yan, freedom to stipulate. So, if the parties stipulate that seller is still the owner despite delivery, seller is still the owner. Seller or his agent is consignee. Ibig sabihin, sa bill of lading, the goods are deliverable to seller or agent. Yung seller ang nag-contract with the carrier, so siya rin ang consignee. Kasi yung nagpadala is called your consignor or shipper. Tapos, pagdating dun sa bill of lading, siya rin ang lumalabas na consignee or the person who will receive the goods. So anyway, in the bill of lading, if it is deliverable to the seller or agent of the seller obviously reserves ownership to the goods, and the carrier is a bailee not for the buyer but for the seller. So the carrier will hold the goods not for the seller but for the buyer. Kasi 'di ba ang general rule natin is pagka naibigay mo na sa carrier, sa buyer na 'yon. Ownership already passes to the buyer. Kasi nga remember, ownership passes by delivery. So general rule, delivery to carrier, delivery to buyer, but in letter B, remember, this is not the case because here the buyer cannot get the goods, because to get the goods you have to present also the bill of lading to the carrier. What else? Seller's title is only for the purpose of security. So title to the goods is held by the seller for the purpose of security. Anong ibig sabihin ng for the purpose of security? Para sigurado siyang mabayaran siya. So i-reserve muna ng seller yung ownership hanggang sa siya ay fully paid by the buyer. But here, remember class, the buyer bears the risk of loss for deterioration. So, yun ang tandaan natin sa number 3. Number 4, buyer or his agent, but seller retains a bill of lading. So, remember here, class, bill of lading, even if it states that the consignee is the buyer or his agent, pero tinago ito ng seller or yung agent ng seller. So, imbis na mapepresent ng buyer ito sa carrier para makuha niya yung mga goods, hindi niya maipresent kasi hindi nga binigay sa kanya yung bill of lading. So remember here, the buyer cannot also get the goods. That's why here, even if the goods are delivered to the carrier, seller retains ownership. What else? Bill of lading sent forward with draft attached. So here, bill of lading is addressed to the buyer, meaning the buyer is the consignee. And yung bill of lading, ibinigay na rin sa buyer. Eh, di ba, okay na yun, pwedeng-pwede nang i-claim ng buyer. But remember here that in the bill of lading, a bill of exchange is attached. But doon sa case na to, the buyer does not honor the bill of exchange sent along with the bill of lading. So, ang nangyari dyan, dahil may bill of exchange nga, yung seller is the drawer. The drawer/seller orders the buyer to pay yung instrument. So, yung bill of exchange which is delivered together with the bill of lading, hindi binayaran ng drawee/buyer yan. That's why here, remember, yung seller will retain ownership over the goods. So, anyway, siguro yun na muna. Huwag na nating pahirapan kasi wala na ngang negotiable instrument. So, what else? In 1504, this talks about a loss which we have already discussed in 1480. But remember, in 1504, risk of loss generally attends title. Anong ibig sabihin yan? Owner bears the risk of loss. If you are the owner of the property, he will bear the risk of loss. So, kung may title ka doon sa property, sa'yo ang risk of loss. So, anyway, general rule, if the thing is lost by a fortuitous event, the risk is borne by the owner at the time of the loss under the principle of res perit domino, which we have already discussed. Very simple, very basic, but there are exceptions. Number 1, seller reserves ownership of the goods to secure performance by the buyer of the obligations under the contract. So, here, remember, kung here, there is already a delivery to the buyer, but remember, mayroong reservation ng ownership by the seller, and the reservation of ownership is merely a security for payment. But here, risk of loss is assumed by the buyer. So, from the time of delivery. What else? Actual delivery has been delayed through the fault of either buyer or seller. The goods will be at the risk of the party who is at fault, or kung sinong may kasalanan noong delay. So, if it is the buyer, the risk of loss belongs to the buyer. If it is the seller will bear the risk of loss. So, the law here punishes the party at fault. So, in 1480 naman, ito namang risk of loss by fortuitous event after perfection but before delivery. In 1480, it's very clear. After perfection but before delivery, sabi sa 1480, risk of loss belongs to the buyer as an exception to the res perit domino rule. So, if the buyer has not paid the price, remember, the seller can recover the price even though the object is lost by a fortuitous event. However, in the first paragraph of 1504, this will present a contrary rule. So, sabi sa 1504 paragraph 1, the goods remain at the seller's risk until ownership therein is transferred to the buyer. So, obviously, this is contradicting. But, maraming provision ang nagsusupport dun sa sinabi sa 1480. Sabi nga ng book ninyo, this conflict can only be resolved by legislation. So, acknowledge naman na meron talagang conflict. And the only way to resolve this conflict is palitan natin or i-amend natin yung law. So, 1480 kasi, risk of loss after perfection but before delivery is shifted to the buyer as an exception to the res perit domino rule, even if the buyer has not yet acquired ownership. So, yun ang tandaan natin sa 1480 in relation to 1504. So, 1505 talks about sale by a person who is not the owner of the object. So, remember, class, ang general rule natin is that no one can give what he does not have or transfer a greater right to another than he himself has, because a sale is a derivative mode only of acquiring ownership. The buyer will get only the rights of the seller. So, pagka derivative, ibig sabihin, this is a right derived only from the source. So, ang source dito is yung seller. Now, if the seller does not have a right to the object, edi yung pinagbentahan niya will also have no right over the object. Now, yun ang general rule. But obviously, there are exceptions. So, number 1, where the owner of the goods is by his conduct precluded from denying the seller's authority to sell. So, it appears na yung seller who is not actually the owner, he appears to be entitled to sell yung goods because of the act of the real owner. So, here, this exception is based on the doctrine of estoppel. pinalabas ba naman ng owner na mayroong right na magbenta itong third person na to, although he has no right talaga. But because nangyari yon, somebody is made to believe na meron siyang right na magbenta and kasalanan ng owner, remember, this is an exception. So here, the buyer will have a right to the goods. What else? Number 2, when there is where the law enables the apparent owner to dispose of the goods as if he were the true owner thereof. So this will talk about yung mga laws on agency. Yan, mga factors law. Wala tayo talaga sa Philippines niyan pero ang katumbas niya sa atin is yung law on agency na civil code. So anyway, apparent owner, so parang siya yung may-ari, and here the law enables him to dispose of the goods as if siya yung true owner, so authorized to sell. So anyway, recording laws, other laws, yung mga recording laws, meron itong effect doon sa mga sales. Anyway, hindi na natin masyadong i-discuss yan, masyado ng technical, pero here, remember, laws which allow yung apparent owner to dispose of the goods, parang siya yung true owner. So, agent, parang he is allowed to dispose of the goods because he is authorized, as if he is the true owner. So, yun lang ang ibig sabihin yan. Number 3, where the sale is sanctioned by judicial or statutory authority. Ibig sabihin, the sale is allowed by law. So here, usually, ang nire-refer nito is Article 559 of Civil Code. So, person in possession of a movable property acquired in good faith is equivalent to title. So, pagka nahanap mo yung, meron kang movable property, tapos you acquired it in good faith, ikaw ang may-ari, ikaw na ang, it is equivalent to title. So, even if hindi naman talaga sa'yo yun. But if you acquired it in good faith, remember, equivalent to title. But remember also in 559 that a person who has lost any movable, or halimbawa, he is unlawfully deprived thereof, may recover it from the person who is in possession of the same. So, meron kayong movable property, tapos nakita nyo sa ibang tao, pwede nyong i-recover ito. Halimbawa, nanakaw yung tablet ninyo, tapos nakita nyo sa in possession of another person, you can recover this item. Now, also take note that if yung taong, di ba, nanakaw yung cellphone ninyo or yung tablet ninyo, tapos itong taong to na who is in possession of your cellphone or your tablet acquired it in a public sale, pwede mo pa rin i-recover yan. But remember, you have to reimburse yung binayad noong third person who is in possession of the object that you have lost unlawfully. What else? If the sale is made at a merchant store, fairs or market, so pagka ang nagbenta sa, nabili nyo yung object sa merchant store, fairs or market, it is presumed to be yours. And remember, if the seller is not the owner, walang problema yon kasi nabenta mo naman siya sa merchant store, fairs or market. So here, class, sale is necessary to facilitate commercial transactions. So, para nga naman hindi magulo, syempre pagka binili mo sa store, tapos bigla merong kumukuha sa'yo, naghahabol, edi lagi na lang ganon. So, it is detrimental to the economy, and yun sa mga sales nga, na kailangan bago mo bilhin sa market, o sigurado bang sa ito, imagine bibili mo sa palengke, bibili mo sa department store, etc. Kailangan mo pang i-verify yung ownership noong seller. Syempre, magulo yan. So, pagka nabili mo raw sa merchant store, fairs, or market, exempted na yan sa rule na even if the seller is not really the owner, the buyer will have title to the goods. What else? Seller has voidable title. Anyway, the title has not been avoided yet, or hindi pa na-annul yung title niya. We will discuss later on. Seller subsequently acquires title. So, this is obviously an exception. Kasi, nung time na binenta ng seller, hindi naman sa kanya, pero later, the seller acquires title. Obviously, the seller can transfer yung kanyang right doon sa buyer. So, in 1506, this is a sale by a person with avoidable title. So what are the requisites for acquisition of good title by the buyer? So number 1, before the title of the seller, the buyer acquires it before the title of the seller has been avoided or invalidated. What else? The buyer acquires it in good faith for value, and he has no notice of the seller's defect in a title. So remember here, the basis of the rule is that where one of two innocent parties must suffer, he who placed the offender in a position to do wrong must suffer. So yun ang tandaan natin. Pagka in good faith acquired, tapos hindi pa naman avoided yung title, and nagbayad naman ng price yung buyer, the buyer will acquire good title to the goods. So take note also na pagka bumili kayo galing sa magnanakaw, as a general rule, thief or a person who stole from another person, yung buyer cannot get title to the goods, because obviously yung owner, original owner, has been unlawfully deprived of the goods. So as a general rule, yung totoong may-ari, remember, nabili mo sa magnanakaw, so yung totoong may-ari can reacquire the goods without paying any reimbursement thereof. Therefore, pero again, katulad ng sinabi ko kanina, if the object is bought by the buyer sa isang public auction, even if the buyer is in good faith and the seller is in good faith also, the true owner can get pa rin the object. And remember, this time, because it is a public sale, the owner must reimburse yung buyer who is in good faith. So mahirap palang bumili sa magnanakaw. So what else? 1507 talks about documents of title to goods. So please take note of the definition of a document of title. It will include a bill of lading, dock warrant, kedan, warehouse receipt, or order for the delivery of goods. So, kung sino ang may hawak ng document of title, siya ang pagbibigyan ng goods ng person who is in possession of the goods, like a carrier or a warehouse man, etc., etc. So, yung warehouse receipt, syempre, yan ay i-issue ng warehouse man. So, let us say, meron akong goods, tinabi ko sa isang warehouse, ako yung seller, so, ilalagay ko siya sa warehouse na yan. Tapos, yung warehouse man will issue a warehouse receipt to me. So, para ma-claim yung goods dun sa warehouse man, the person who claims must present yung warehouse receipt. Yung warehouse receipt is a document of title to the goods. So, documents of title obviously may be negotiable and non-negotiable also. Please take note of the term goods, take note of the term order. So anyway, nature and function of documents of title. So they are receipt of or orders upon a bailee of goods represented. So remember, here, this will refer to goods, not to money. Ito ay mga resibo na inisyu ng bailee. And remember, kailangang i-present yung mga documents of title para makuha mo yung goods na nandun sa carrier or bailee or warehouse man. Yung bailee, siya yung nagtatago ng goods. Siya yung may possession ng goods. Yung carrier, nasa kanya din yung goods. So, para makuha mo sa kanila, present mo yung document of title. So, what else? Evidence of transfer of title and possession of the goods and contract between the parties. So, remember, a document of title is symbol of the goods covered by it. So, remember, it is evidence of transfer of title. So, kung yung seller, binigay niya yung document of title sa buyer, meron ng transfer ng title. Also, transfer of possession. And obviously, there is a contract between the parties, like a seller and a buyer. So, ito ay isang evidence din ng contract nila. So anyway, yun muna ang tandaan natin sa nature and function of a document of title. So the most common is yung bill of lading, which I already discussed. So contract, and a receipt for transport of goods and their delivery to the person named therein to order or to bearer. Bearer. What else? Yung dock warrant naman, dock owners ang nagbibigay. So, ito yung mga nasa port, yan, yung sa mga nasa malapit sa dagat, yung mga galing sa barko, yan ang mga dock warrant. So, ilalagay sila sa warehouse on a dock. Yan. So, anyway, what else? Warehouse receipt. So, warehouse man, siya ang nag-i-issue nito. So, yung warehouse man, meron siyang undertaking dun sa isang warehouse receipt to hold and deliver the said goods to a specified person na makakapag-present ng warehouse receipt. So, a kedan is a warehouse receipt usually for sugar received by a warehouse man. So, the classes of documents of title may be negotiable under 1507. So, yung negotiable document of title, yung bill of lading, warehouse receipt, etc., you can endorse it or negotiate it to other persons. So, kung ikaw yung buyer na naghahawak ng document of title na yan, pwede mong ibigay sa iba or i-transfer i-negotiate sa iba. Tapos yung, syempre, negotiate, obviously, this is for a price. Tapos yung person na yan will be the one to claim from the warehouse man, bailey, etc., yung mga goods. What else? Document of title may also be non-negotiable. So, this document of title is deliverable only to a specified person. So, pagka negotiable, to buyer and or order. So, any person who is ordered by the buyer natatanggap ng goods. So, yun ang negotiable document of title. Pagka non-negotiable, to buyer, period. So, this cannot be negotiated further. So, it is the buyer who must receive the goods from the bailey or warehouse man. So, 15 as ito pala yung example ng isang negotiable document of title. In this case, this is a warehouse receipt. So, nakita ko na naman ito sa internet. So, mayroong mga description ng goods yan. Kailangan talaga mayroong description so that the goods will be identified. So, kailangan din ilagay kung sino yung consignee ng goods. And dito ilalagay sa portion na to yung mga endorsement. So, yung mga endorsement, parang let us say, bakit naman ang kulay? To X, yan. Tapos signed buyer, yan. So, buyer. Hirap naman. So, buyer. So, yun ang isang endorsement. So, yung X na yan, again, can endorse to another person later on because this is a negotiable warehouse receipt. So, yung last endorsee will be the one to claim yung goods from the bailey, carrier, warehouse man, etc., etc. So, what else? In 1508, two forms of negotiating a document of title, mere delivery or endorsement plus delivery. If it is negotiated by mere delivery, ito yung mga bearer negotiable documents of title. So, to bearer. So, whoever is the holder. So, dun i-deliver sa kanya. So, ang mga bearer, basta i-deliver mo lang yung warehouse receipt, bigay mo lang ng bigay kung kanino man na kailangan mo siyang ibigay. So, yun ang negotiation. Now, if it is an order instrument, endorsement plus delivery. So, yung diniscuss ko kanina, to X, signed buyer, tapos, yung kanyang signature doon, tapos yung nilagay niyang to X is an endorsement. So, pagkatapos niyang i-endorse, i-deliver niya sa kay X, dun sa endorsee. So, anyway, please take note also yung spelling ng ay talaga siya sa law. Hindi naman ako nagkamali sa part na yan. So, what else? Negotiation of a negotiable document by delivery. So, if it is deliverable to bearer, like I said a while ago, if deliverable to the order of a certain person. And then, yung certain person has endorsed it in blank. So, kung halimbawa, yung order instrument. So, yung instrument ang nakalagay, ang kanyang consignee is to buyer or order. So, i-deliver yan kay buyer or kung sino man ang in-order ni buyer who may receive the goods. Now, itong si buyer, because this is an order instrument, can endorse it to a specified person, to X, signed buyer. Now, also, remember, class, na itong si X, pwede rin niyang i-endorse na naman to a specified person, to Y, signed X. But itong si Y, also, may negotiate it again to a specified person like to B, ganyan. Pero, kung halimbawa, in-endorse ni Y to tapos blank lang, nakalagay lang na blank, or pinirmahan lang bigla ni B. So, this is negotiated in blank or endorsed in blank. So, yung mga endorsement in blank are considered as bearer endorsement na yan. So yun ang in that case, remember, the instrument can now be negotiated by mere delivery. So pwedeng i-convert yung order instrument into a bearer instrument. 1510, what is the effect now if parang meron akong na-skip. Hindi, wala pala. So anyway, negotiation of a negotiable instrument by endorsement of and delivery. So negotiation by endorsement can be affected, pagka order instrument can be affected only by endorsement plus delivery. So yun ang tandaan natin. So what else? Endorser in blank or to bearer, endorsed to a specified person, etc. I think I discussed this already in passing. Medyo excited pala akong mag-discuss. So, anyway, this is 1509. So, in 1508, yung negotiation by delivery. Ito namang 1509 is negotiation by endorsement and delivery. So, again, applies to order instruments. So, remember, class, sa letter A, if yung order instrument is endorsed in blank or to bearer, yung order instrument becomes negotiable by a delivery or it becomes a bearer instrument. Now, if it is endorsed to a specified person, pwede naman, it may again be negotiated by endorsement of the specified person in blank or to bearer or to another specified person. So, delivery alone is not sufficient. So, again, yung example ko, to buyer ang original consignee, buyer or order, tapos yung buyer, ine-negotiate niya kay X, so nilagay niya 2X, tapos signed buyer. So, itong si X, sabi nga dito, may endorse it in blank or to bearer or to another specified person. Pero dahil dumating kay X ito na order instrument, kailangang pagka in-endorse niya to, delivery plus endorsement. Yung mga sumunod kay X, syempre kung halimbawa it is endorsed in blank, yung mga sumunod kay X, pwede na lang nilang i-endorse by delivery. Kung ito ay bearer, pwede na rin lang i-endorse to delivery. Now, if it is another specified person, we will apply again the rule on order instruments, endorsement plus delivery. So, 1510 talks about placing the word non-negotiable sa isang negotiable document of title. So, anyway, this will have no effect. The document will continue to be negotiable. So, yun ang tandaan natin. It does not destroy the negotiable character of yung words na non-negotiable does not destroy the negotiable character of the negotiable document of title. So, 1511, non-negotiable documents cannot be negotiated, but they can be, remember, transferred or assigned by delivery. So, yung transferee acquires only the rights of the transferor. So, the transferee will acquire no additional right kahit na i-endorse mo pa yan. So, anyway, take note of that. Basta negotiable ang document of title, ang negotiation pwede kasi nga negotiable. Now, negotiation may be by delivery in case of bearer instruments. Pagka naman endorsement plus delivery, this is in case of order instruments. Now, non-negotiable documents cannot be negotiated, obviously, pero it can be transferred. So, yun ang tandaan natin. So, 1512, persons who may negotiate a document, the owner, and also the person who is entrusted with the custody of the document. So, what else? Rights of person to whom document has been negotiated. So, obviously, sa 1513, it talks about negotiable documents of title. So, the person to whom the negotiable document has been negotiated, makukuha niya yung title ng person who negotiates the document. What else? Title of the person to whose order by the terms of the document the goods were be delivered over such goods. So, in short, yung lahat ng rights ng nag-negotiate makukuha nung taong pinag-negotiatean. What else? Also, remember, Bailey will have an obligation to the person to whom the document has been negotiated to hold possession of the goods for him as if yung Bailey contracted with the endorsee of the instrument or the person na kung kanino mo negotiate yung instrument. What else? In case naman of 1514, this obviously talks about non-negotiable documents of title. Kasi nga hindi siya pwedeng i-negotiate, ita-transfer lang siya. Yung mga transferee, meron pa rin siyang right. So, ang title lang niya to the goods is against the transferor. So, yung right lang niya is against yung immediate na nag-transfer sa kanya. Hindi katulad ng negotiation. Kung may bang nagkiklaim, hindi papansinin yung kanilang right. Kasi ikaw yung may superior right doon sa goods if you paid value for the goods tapos nasa iyo yung document of title. What else? Number 2, the right to notify the Bailey of the transfer. And number 3, the right to acquire the obligation of the Bailey to hold the goods for him. So, attachment of the goods covered by the document transferred. So, again, this talks about non-negotiable documents of title. So, in 1514, kasi tandaan nyo, hindi nga na-negotiate ang isang non-negotiable document of title. So, yung right ng transferee is only against the transferor. Now, what if may mga creditors? Yung transferor. Tapos, yung mga creditors na yan, pina-attach nila yung goods. So, pina-reserve nila for the payment of debt noong transferor. So, yung creditor ng transferor, dinimanda siya. Tapos, later on, yung transferor, who is also the debtor of the creditors, he is adjudged liable for the debt. So, ngayon, yung mga creditors, pwede nilang kunin yung goods in the name of the transferor / debtor. So, yun ang pinagkakaiba niyan. Because, remember, yung right ng transferee may be defeated by the rights of the creditors. So, pwede nilang makuha yung goods. Now, if the document is negotiable, as in 1519, yung goods cannot be attached or levied under an execution. So, in short, pagka negotiated ang goods, mas maraming right yung nakatanggap ng negotiated na document of title. So, hindi pwedeng galawin ito ng mga creditors. So, again, yung right ng person to whom a negotiable document of title is negotiated is superior doon sa mga creditors. So, anyway, rights of the person to whom order document was transferred by endorsement. So, remember class here that dahil nga ito ay order document, tapos this is transferred by endorsement kasi nga order document, ang kanyang transfer is by endorsement. So, rights right to the goods against the transferor, and right to compel the transferor to endorse the instrument. So, in 1515, the document is negotiable. Pero imbis na i-endorse doon sa pagbibigyan, ang ginawa ng, let us say, buyer, ganyan, imbis na i-endorse, transfer lang niya or inassign niya. Bakit mo naman i-assign yan, ita-transfer? Pwede mo namang i-negotiate. So, the rights of a person to whom the order document, meaning order document, it is negotiable, was transferred by endorsement. Not by endorsement is, remember, rights as against the transferor, and number 2, the right to compel the transferor to endorse the instrument. So, pwede mong pilitin. Negotiable naman ito. Bakit hindi mo na lang i-endorse sa akin? So, yun ang 1515. So, anyway, if the document is subsequently endorsed, the negotiation shall take effect as of the time when the endorsement is actually made, not at the time the document is delivered. 1516, warranties on the sale of documents. Document is genuine. He has a legal right to negotiate or transfer it. Knowledge of no fact which would impair the validity or worth of the document. Right to transfer title to the good, and the goods are merchantable or fit for a particular purpose. So, ito ang mga warranties na binibigay ng endorser sa isang negotiable document of title. So, yun ang mga promise niya na nung transfer niya yung instrument, totoo yung instrument, meron siyang legal right to negotiate, wala siyang, he is in good faith, he has no knowledge of any fact which would impair the instrument, right to transfer title, and yung mga goods covered by the document of title are merchantable, fit for a particular purpose. What else? Warranties in negotiation or transfer. This refers to warranties of a person who negotiates and person who assigns or transfer for value. So, the warranties here are about the document, about the right to the document, and about the goods represented, that they are merchantable. So, anyway, actually, itong mga to, in-expound lang nila yung 1516. So, yung mga warranties ay binibigay ng taong nag-negotiate or binibigay ng tao na nag-assign noong non-negotiable. And also, remember, the warranties will cover the document, the right to transfer the document, and also that the goods are merchantable. So, what else? 1517, endorser of a negotiable instrument. Endorsement of a negotiable instrument has double effect. So, remember, in 1517, conveyance of the instrument and also contract of endorser with the endorsee that on certain conditions the endorser will pay the instrument if the party primarily liable fails to do so. So, pagka in-endorse yung document of title, so remember here class that yung endorsee will pay the instrument, meaning he will deliver the goods to the pagka nagkaroon ng negotiable document of title, pagka present na ito dun sa warehouse man, sa mga carrier, ganyan, remember class here that the carrier should deliver to the person who presents yung document of title. Now also, if yung person who is primarily liable, meaning yung carrier, warehouse man, bailee, fails to deliver yung goods, remember class that the endorser will pay the instrument. So, ang magbabayad yan yung endorser. Bakit? Kasi nag-warrant siya na meron siyang title, nag-warrant siya na document is genuine, nag-warrant siya na goods are merchantable, nag-warrant siya na meron siyang right to transfer the instrument and right to transfer title to the goods. Tapos bigla yung carrier hindi deliver. So, remember, magiging liable yung endorser. So, yun ang tandaan natin doon sa 1517. Yan. What else? 1518. Negotiation is not impaired by fraud, mistake, duress, etc. So, remember in 1518, a negotiable document of title may be negotiated by any person who is in possession of the negotiable document of title. So anyway, any person may negotiate it, including even a thief or a finder. So yung holder, if he is not aware of the defect of title of the thief or finder, will have a good title to the document of document. So nakikita nyo yung pinagkaiba ng negotiation at saka ng assignment. So yung assignment, it applies to non-negotiable documents of title. So kung ano lang yung right ng nag-transfer, yun lang ang right ng nakatanggap ng non-negotiable document of title. So let us say it turns out na yung nag-transfer is a thief or a mere finder but not entitled really to the non-negotiable document of title. Obviously, yung makakatanggap, the transferee, will have no right. In case naman of negotiable documents of title, kung halimbawa, ako yung nag-endorse, nag-negotiate ng negotiable document of title, ni-negotiate ko siya. Pero yung document of title na yun, ninakaw ko lang. Remember, class, na if yung pinag-negotiatean ko does not know of the defect of my title, meaning he is in good faith, remember na yung nakatanggap na yan may have a greater title than what I have. So, he will have good title if he paid value. Therefore, kung binayaran niya ako and he is in good faith and he is not aware of the defect sa aking title. So, sa negotiation, yung holder or yung person who receives yung document of title through negotiation can have a better right than the person who is negotiating it. Pagka non-negotiable, remember, kung ano lang yung right ng negotiate, so kung wala siyang right, wala ka rin right as a transferee or assignee. Now, 1519, this talks about rules regarding attachment or surrender. So, this will apply if the document is negotiable. So, attachment, general rule, hindi pwedeng i-attach or levy. Katulad nga nung sinabi ko kanina, yung mga goods ng mga creditors. Exception, if the document is surrendered to bailee. What else? Negotiation of the document is enjoined or prohibited. So remember, if the document is surrendered to the bailee, in short, yung negotiable document of title, binigay na sa bailee, syempre, wala nang magagawa yung bailee doon kung hindi ibigay yan kung sino man ang nag-present nung negotiable document of title. Kung ang creditors ang nag-present nun, wala nang magagawa yung bailee kung hindi ibigay sa kanya, yung sa creditors, yung goods. So, what else? Surrender naman of goods. Remember, general rule, bailee cannot be compelled to surrender the goods except if, again, the document is surrendered to him. So, whoever surrenders a document, the bailee has an obligation to give yung mga goods do sa nag-surrender doon sa document of title. If the document is impounded by the court, syempre, wala na siyang magagawa kung hindi sumunod doon sa order ng court. So, 1520 naman talks about remedies to reach unnegotiable instrument. So remember, as I've said a while ago, hindi pwedeng i-attach or levy or kunin ng mga creditors. Sa madaling sabi na lang para hindi na tayo mahirapan, yung mga goods covered by a negotiable document of title. Now, in 1520, binigyan nila ng exception to. Courts have the full power to aid by injunction yung creditor so that he can get a negotiable document of title covering yung mga goods na kiniklaim niya. So, here, remember, yung creditor, meron siyang debtor. Yung debtor, meron siyang negotiable document of title. So, syempre, yung negotiable document of title niya, hindi pwedeng kunin ng mga creditors yan. Exempt yan. But also, take note that the court may compel yung surrender nung negotiable document of title by injunction. So, Yun ang tinatawag nila. Injunction is, titignan ko yung kanyang simple definition. So, let us, I will take a look. Usually, injunction is court order to compel a person to carry out a certain act. So, anyway, ganun nga. Sa pilita, the court will compel yung bailey to deliver yung or compel the debtor to deliver yung negotiable document of title doon sa creditor niya. So, anyway, hindi ganun kadali. So, pagka kasi negotiable document of title, lalong-lalo na kung ito ay na-endorse na sa third person, mahirap nang kunin talaga ng mga creditors ito. So anyway, that is 1520. Tama, 1520. 1521 talks about specifications for delivery. So this will talk about the place of delivery, time of delivery, and manner of delivery. So rules regarding place of delivery, agreement, express or implied, that is the place of delivery agreed upon. So kung ano yung napag-usapan, yun ang place of delivery. This is a rule we have already studied in obligations and contracts. If there is no agreement, place of delivery is determined by usage of trade. So this is place of delivery in case of sale. Now, if there is no agreement and no usage of trade, place of delivery is the seller's place of business. What else? Place of delivery is in the other case is the seller's residence. Now, in case of a specific goods, tapos it is in some other place, that place is the place of delivery. So, kung kotse, tapos alam nilang nandito sa ganitong lugar, alam ng mga buyer and seller, remember, that is the place of delivery. If there is no agreement or usage of trade to the contrary. So, what else? Ano pa bang kailangan ito? Rules regarding time of delivery. So, time of delivery is also by agreement or by usage of trade if there is no agreement of the parties. If no time is fixed by the contract, seller must deliver within a reasonable time. So, what is reasonable is a question of fact depending on the circumstances, and it can be proven by extrinsic evidence. So, evidence aliunde. So, anyway, circumstances to consider, character of the goods, madali bang masira yan? So, ang reasonable time dyan, agad-agad i-deliver. Kung hindi, pagka nakuha ng buyer, baka sira na. Purpose of the object na binibili. What else? Ability of the seller to produce the goods. So, you have to take into consideration kung ginagawa pa rin yung, minamanufacture pa yung goods. So, syempre, mas matagal yon. Transportation facilities, you have to consider also dun sa definition ng reasonable time, distance. Kung halimbawa, galing pa siya sa Mindanao, syempre, wag mo expect na kinabukasan or after 2 hours, nandyan na. What else? A usual course of business in that particular trade. So, yun ang factors to consider and to define whether or not yung time is reasonable time. So, in letter C class, if the contract provides a fixed time for performance, so merong fixed time for performance, kailangan muna nating tignan if time is of the essence noong contract of sale. So, pagka time is of the essence, remember, performance must be given or offered within the time essential to the contract. Now, if time is not of the essence, kailangan correct performance must be offered within a reasonable time. Now, also, in letter D, if the contract does not specify the time for delivery, so that delivery is to be made within a reasonable time, time is not of the essence. So, obvious naman yan eh. Kasi kung time is of the essence, yung contract should specify yung time. So, in letter D, remember also that yung buyer, hindi niya pwedeng sabihin na time is of the essence of the contract if hindi niya i-notify yung seller yung kanyang intention to cancel unless delivery is made on or before the fixed time. So, kung gusto nyo talaga na yung sale nyo, nandun yung time as a motivating factor, meaning time is of the essence, kailangan mag-fix kayo ng time. If hindi kayo nag-fix ng time, obviously, time is not of the essence. Now, para magkaroon ng, para maging, motivating factor yan, kailangan magbigay ang buyer ng notice to the seller na kung hindi mo ma-deliver within the time fixed, I have intention to cancel the sale. So, yun ang letter C and D also. So, anyway, take note also of yung manner of delivery of goods when the goods are in the hands of a third person. So, here, third person must acknowledge that he holds the goods not in behalf of the seller anymore, but on behalf of the buyer. If hindi in-acknowledge ng third person na, oy, itong goods na to, I'm keeping it for the buyer, I'm keeping them for the buyer. Remember, the seller has not yet delivered yung goods. So, it will not apply in case there is a negotiable document of title, and also if the goods are still to be manufactured. So, applies only to existing goods, but these are in the hands of a third party. So, rules regarding hour of delivery of goods, reasonable hour of the day. So, demand or tender of delivery para maging effectual, kailangan reasonable hour of the day. What else? Reasonable hour is a question of fact depending on the circumstances. What else? Number 3. In case of goods which are bulky or need special care, remember here, class, that an hour might be unreasonable, which would not be so in an ordinary payment of a small sum of money. So, kung usually objects, di ba, seller is required to put the object in a deliverable state. Now, if yung, syempre, pagka maliit lang yung goods, madali lang nilang maipapak yan. So, pwede na nilang i-deliver kaagad. But obviously, if the goods are bulky or they need special care, syempre yung hour, hindi na pwedeng isang oras lang, hindi pwedeng maiksing time lang. Unlike in case of small items. So, yun ang kailangan nating tandaan. Duty of seller to put goods in deliverable condition. Again, here, seller will bear the expense to put the goods in a deliverable state. So, kailangan siya ang magbayad ng bubble wrap, class. Hindi yung maniningil sila ng extra. Kung gusto mo naka-bubble wrap yung goods mo, kailangan magbayad ka ng extra 5 piso. Hindi dapat yung mga ganon. So, anyway, yung deliverable state is yung state that the goods are in where the buyer would be bound to take delivery of them. So, also take note that this will be true even if the buyer has the duty to take delivery. So, yung buyer, kukunin niya yung goods doon sa place of business of seller. The seller must still put yung goods in a deliverable state and also pay expenses therefore. 1522 talks about quantity of goods, and here the quantity of goods delivered is less than that agreed upon. So, mas konti yung dineliver kaysa dun sa napag-usapan. Obviously, the buyer may reject because there is no integrity. Kung i-apply natin yung rules sa oblicon, there is no integrity of prestation. Now, also, buyer may accept what has been delivered at contract rate if he knows that no more delivery is to be made. Now, if he did not know that the seller is going to be guilty of breach, akala niya dadalhin pa yung kulang. Remember, tapos hindi na dinala. Remember, class, that the buyer must pay yung fair value of the goods. So, example na lang para mas mabilis. So, anyway, let us say, buyer, bumili siya ng 100 cans of disinfectant. Yan na lang. 100 bottles na lang, di pala nakakan ng disinfectant. So, tapos, bigla, dun sa 100 bottles of disinfectants, 100 lang, ay 60 lang ang dumating. 60. So, 100, tapos 60 lang ang dumating. So, anyway, remember, class, here, that the buyer may reject yung entire delivery because there is no integrity of prestation. Now, let us say, in the meantime, nung dineliver yung 60, tinanggap ng buyer yan. Now, if the buyer accept this goods na 60 lang, remember, he has to pay it. Ngayon, kung ang babayaran niya is contract rate or fair value, will depend. So let us say class, yung buyer upon receiving yung 60 bottles of disinfectant, bigla ibinenta niya sa market. Yan. Nung binenta niya sa market, dahil nga bago yung brand ng disinfectant, binenta niya at introductory price. So let us say, yung bawat disinfectant, ang binayad niya dyan ay, let us say, 300 per bottle. Pero dahil introductory price at he is trying to market yung kanyang product na ibebenta, yung disinfectant, imbis na ibebenta niya na may tubo, binenta pa niya ng palugi para lang ma-i-advertise yung kanyang product. So let us say binenta niya ng 250 pesos only. Now, let us say noong binigay sa kanya yung 60, alam niya na wala nang i-deliver na more product. So, tapos binenta niya ng, remember, 250. But the contract is 300. So, ang babayaran niya, remember, is the contract rate of 300. Now, if nung dineliver yung 60, tapos inakala niya na meron pang i-deliver pa yung kulang, tapos later on hindi na pala i-deliver, remember that the buyer here has to pay yung fair value of the goods to him. So remember, he must pay the price, but yung babayaran niya is yung fair value of the goods received. So yung fair value is it means class that the benefit which the buyer may have received from the goods. So the benefit that the buyer received from the goods here is 250 lamang kasi nga binenta niya ng palugi dahil nga introductory price. Remember, yun lamang ang kanyang babayaran because the seller here is guilty of breach. So yun ang rules when quantity is less than that agreed upon. Paano kung mas marami? Again, we will take a look at 1522. Buyer may reject all. Kasi ito lang sabi ko, 100 bottles of disinfectant. Tapos, i-deliver mo, mas marami pa. Saan ko ilalagay yan? So, pwede niyang i-reject all. Buyer may also accept the goods agreed upon and reject the rest. So, let us say 200 ang dineliver, 100 lang in-order niya. E di, tanggapin niya yung 100. Huwag niyang tanggapin yung sobra na 100 pa. What else? If he gets all, meaning he will get yung entire 200 bottles of disinfectant, he must pay for them at contract rate. So, yun ang tandaan ninyo sa yun, contract rate. So, here, let us say each is 300. Yun ang contract rate. So, kailangan niyang bayaran yung disinfectant 200 bottles times 300, which is contract rate. So, for these rules to apply, remember, quantity must have been fixed prior to the agreement. So, paano naman, ma'am/sir, if quality is different from that which has been agreed upon or goods are mixed with others? So, the rules are, pwedeng i-accept yung goods which are in accordance with the contract. So, kung ano yung umakma dun sa pinag-usapan, yun lang ang tanggapin mo and reject the rest as well. Now, also, if subject matter is indivisible, buyer may reject the whole of the goods in case there is delivery of a larger quantity of goods or there is delivery of mixed goods. So, what else? Titingnan natin. Application of usage or of trade, special agreement or course of dealing. So, here class, special application of general rules concerning contract. If we allow yung evidence of usage, trade, or special agreements in dealing between buyer and seller. So, anyway, common kasi daw yung pagmiminggal ng goods of different owners to constitute a co-ownership in a whole mass of specified quality. So, anyway, basahin nyo na lang siguro yan. Delivery to carrier in 1523. So, general rule, delivery to carrier is delivery to buyer. So, seller is authorized or required to send goods to the buyer. General rule, delivery of goods to carrier is delivery to buyer. Except number 1, if there is a contrary intention, parties did not intend delivery of the goods to the buyer through the carrier, and those provided for in paragraphs 1, 2, and 3 of Article 1503, which we have already discussed. So Article 1523 talks about the seller's duty after delivery to the carrier. So here, class, remember, the obligations of the seller are respectively subject to the specific instructions of the buyer. So remember, class, the seller must enter on behalf or for the benefit of the buyer into such contracts reasonable under the circumstances. So remember, seller must enter into a contract with the carrier for the benefit of the buyer, and kung hindi if the seller does not enter into these kinds of contract with the carrier, the buyer may refuse to treat delivery to carrier as delivery to himself. Remember, the general rule is that a delivery to carrier is a delivery to the buyer already. So, syempre, kung i-decline ng buyer to treat this delivery to carrier as delivery to buyer or himself, yung goods, in case the goods are lost or damaged in course of transit, seller is responsible for damages. So, yun ang tanda natin dyan. Number 2, also, to give notice to buyer regarding necessity to insure goods. So, seller must also notify yung buyer na kailangan i-insure yung goods during transit kasi under the circumstances, usual na i-insure yung mga goods. So, if the seller does not notify the buyer that the buyer has to insure the goods will be at the risk of the seller. So, seller is not liable. Meron siyang exception. Seller is not liable for loss of goods if the buyer had all the information which will enable him to insure the goods without the notice of the seller. So, what else? Kinds of delivery to carrier. It may be collect on delivery. So, remember, COD is not actually cash on delivery, but it is collect on delivery. So, anyway, sa COD, carrier acts for the seller yan, in collecting the purchase price. So, buyer must pay for the goods bago niya makuha yung possession ng goods from the carrier. So, COD terms do not prevent title from passing to buyer on delivery to carrier where they are solely intended as security for purchase price. What else? It can also be CIF, cost, insurance, and freight. So, remember, in cost, insurance, and freight, since the selling price includes insurance and freight, so kasama na sa binabayaran ng buyer yan, it is understood that said insurance and freight should now be paid by the seller. So, seller ang magbabayad ng freight or yung expenses para sa delivery and also insurance. So, all charges up to the place of destination is paid by the seller. So, take note, class, in CIF contract, the place of delivery is presumptively at the buyer's place. So, kung saan sinabi ng buyer, yun yung place of delivery in CIF contracts. What else? Take note also of free on board. So, FOB is free on board. It may be free on board at the place of shipment. So, here, in free on board at place of shipment, the buyer must pay the freight. What else? In FOB at the place of destination, seller must pay the freight since the contract states this is free on board until the destination. So, sa place of shipment, buyer must pay. Sa place of destination, seller must pay. Now, if it is number 3, free alongside vessel or free alongside ship, FOB alongside or FAS, magkapareho lang daw yan. From the moment the goods are brought alongside the vessel, tinabi na sa barko, etc., buyer must pay for freight or expenses. So, in your book, there are also other kinds of delivery to carrier. So, pag-aralan nyo na lang yung mga ibang yan, yung X-dock, X-factory, etc., X-warehouse, yan, pag-aralan nyo na lang yan. But this is most important bago ko i-discuss yung 1524. So, there are presumptions which will arise based solely on the payment of the freight. So, yung FOB at saka CIF, talagang it makes only presumptions. Pero it will yield to intention of the parties. So, meron tayong CIF na terms, meron tayong FOB na terms. Pero ang magpe-prevail talaga is the intention of the parties. So anyway, if the buyer is supposed to pay the freight, remember, it is reasonable na isipin na yung buyer has become the owner at the point of shipment. Kasi nga siya ang nagbabayad ng freight. Bakit siya ang magbabayad ng freight kung hindi siya ang may-ari? Now, if yung seller ang magbabayad ng freight, remember, ang presumption dyan ay seller will retain ownership of the goods until they are transported to the ultimate destination. So, here, binayaran ng seller yung pamasahe talaga ginamit ko, pamasahe, kasi siya yung may-ari hanggat hindi ito na de-deliver sa kanyang final destination. Final destination pa ako, ano. So, anyway, in 1524, delivery must be simultaneous with the price. If the buyer does not pay, seller is not required to deliver. Bakit? Sales are reciprocal contracts, reciprocal obligation. So, take note here also that the vendor is not required to make delivery if no period is fixed in the contract and also the vendee has not paid the price. So, delivery must be made before payment of the price. When delivery must be made before payment of the price. Here, dito sa paragraph na to, kailangang i-deliver na even if the price is not paid. So, if a period has been fixed for payment, so merong sinabi, 2 weeks, after 2 weeks, dun mo bayaran. Seller must already deliver the thing sold, even if the period has not yet arrived. So, kailangan niyang hintayin yung 2 weeks before he can demand price, except if the the buyer has lost the benefit of the period. So, what else? 1525 talks about the remedies of an unpaid seller. So, first, we have to define kung ano yung unpaid seller. An unpaid seller is a person who has not been paid or tendered the whole price or has received a bill of exchange or other negotiable instrument as conditional payment, and the condition on which it was received has been broken by reason of dishonor of the instrument. So, unpaid seller ka kung hindi mo na tanggap yung buong bayad para dun sa binenta mo. So, kung nakatanggap ka ng cheque or other negotiable instrument and ito ay hindi na good, so, pinakash mo yung check but it was not honored by the bank. So, here, remember, you are still defined as an unpaid seller. So, yung term na unpaid seller will include also agent of the seller, consignor, or agent who has himself paid or is directly responsible for the price. So, agent na nag-abono para dun sa buyer. So, siya yung directly nagbayad ng price, he will become an unpaid seller. What else? Any other person in the position of seller. Seller is unpaid whether or not title has passed to the buyer. So, where whole of the price has not been paid, remember class, tender of payment by the buyer. So, tender of payment, we already discussed tender of payment. So, tender destroys the seller's lien. So, as far as concerns the rights of the seller against the goods, he is not considered as an unpaid seller after tender of the price. So, if the buyer offers the price in legal tender, tapos i-offer niya yung buong amount together with interest cost, etc. Yung buong amount together with other charges. Tapos, buyer offers this. So, meron ng tender. Now, remember class that it will destroy the seller's lien. So, he is not anymore an unpaid seller after tender of the purchase price. If part of the purchase price has been paid, it does not destroy the seller's lien. So, in short, the seller is still an unpaid seller kung portion lang ng price ang binayaran. What else? Payment by a negotiable instrument. So, sabi nga natin, pinag-aralan natin, delivery of promissory notes, etc., bills of exchange, other mercantile documents, does not produce the effect of payment until they have been cashed. So, mere delivery of a negotiable instrument does not extinguish the obligation of the buyer to pay because the negotiable instrument may be dishonored. Still, seller is an unpaid seller if dishonor is indeed made over the instrument. So, the rights of an unpaid seller, actually marami. Possessory lien in 1526 or mas madali sigurong maintindihan kung gagamitin natin yung term na right to retain the goods. Imbis na i-deliver niya, seller will retain the goods. What else? Right of stoppage of goods in transitu. So, kung seller is no longer in possession of the goods, pwede niyang i-stop yung goods in transit, papunta sa buyer, stop niya para buyer will not take possession. What else? Special right of resale, special right to rescind the sale, we will discuss later on. Action for the price, obviously, kung hindi binayaran ng buyer, unpaid seller can file an action for the price para bayaran ng buyer yung goods. Action for damages, pwede rin yan. Recto law is another remedy of unpaid seller. So, foreclosure in case the default covers 2 or more installments. So, foreclose yung property if property sold if a chattel mortgage has been constituted on it. Maceda law, ito yung remedy of the seller in case of sale in installments of real property. So, again, ang mga remedy niya is to give a grace period to the buyer, etc., to cancel the sale. But again, after payment of cash surrender value and sending of notice or of cancellation or demand for rescission by notarial act. And again, file an action for specific performance. So in addition to yung enumeration nga noong mga rights of unpaid seller, remember in 1526, yung even if the ownership of the goods has already passed to the buyer, the unpaid seller may exercise yung rights enumerated dun nga sa 1526. So let's talk about possessory lien. So ang possessory lien is, to be better understood, is the right of the seller to retain the goods for the price while he is in possession of them. So hindi na niya i-deliver to the buyer. Now remember here, pagka merong possessory lien or right to retain yung seller, that possessory lien is lost if the seller loses possession. Kasi nga possessory. So the seller must be in possession. But remember also that the seller will retain a lien on the price. So simply stated, seller's possessory lien on the goods is lost, but his lien on the price remains kung wala na siyang possession. Kasi nga, possessory lien, so the seller must be in possession. In addition to that, remember in 1533, yung 1533 is the special right of resale. Now, objects ay goods which are in the possession of the seller. Later on, the seller decides to resell yung goods na yan. Remember, nagkaroon ng resale, there is a deficiency. Seller may recover the deficiency and also he may recover from the buyer damages for any loss occasioned by the breach of contract of sale. So, yun ang tandaan natin sa possessory lien. In addition to that, unpaid seller's possessory lien may be exercised in case of number 1, sale without stipulation as to credit. So, simply stated, this is a sale not on a credit. So, a sale not on credit, remember, seller will be entitled to the payment of the price at the same time he transfers possession of the goods. So, pagka transfer na niya yung possession of the goods, he is entitled to demand payment of the price. Anyway, the seller will always have a lien upon the goods which he sells until payment or tender of the entire price. So, laging may claim yung seller hanggat hindi pa siya nababayaran ng buo, as long as he is an unpaid seller within the definition of law. So number 2 talks about yung expiration of term of credit. So obviously this is a sale on credit. So in a sale on credit, the buyer is given time to pay for the goods or yung binili niya from the seller. Now sa credit sale, buyer will be in possession of the goods without paying the price. But he must remember, pay the price within the time given to him. Now, if hindi niya nabayaran yung price within the time given, he will lose the right to a period, and also yung seller's right of lien may be exercised. So, if the buyer fails to pay, seller will have yung right of lien. What else? In case also of insolvency of the buyer, this is another situation where the seller's possessory lien is revived even if yung time for payment of the price hindi pa siya dumarating kasi nga siya ay insolvent na and he cannot pay his obligations as they become due. So it revives the seller's lien. So pwede nang of course yung seller will have a claim over the price. What else? Lien is generally lost by partial delivery. So if there is partial delivery, the unpaid seller has a lien upon the remainder for the proportion of the price which is due on account of the goods so retained. So kung ano na lang yung portion, mayroong remainder of portion of the price. So merong claim doon yung seller. So what else? In intention to make such waiver may be inferred from the circumstances. So here yung waiver, it simply means that yung delivery of a portion is intended to be delivery of a whole. So here, because wala nang retention dun sa remainder, kumbaga dineliver niya yung portion lang ng goods, pero ang intention ng parties is to yung delivery ng portion is delivery of the entire goods. So here wala nang possessory lien because nothing is remains in the possession of the seller. So yun ay waiver, remember. So anyway, intention to make such waiver may be inferred from the circumstances. So what else? Remember here, portion lang ang dineliver, walang remainder. Pero dahil may intention to portion, ang intention dyan is to make it delivery of a whole. Remember class na nawawala yung possessory lien. So that is 1528. What else? The unpaid seller will lose yung kanyang possessory lien if there is delivery to a carrier, agent, or bailee of the buyer. So again, the general rule is delivery to the carrier is delivery to the buyer. So pagka na-deliver na sa carrier, agent, or bailee of the buyer, the goods are no longer in the possession of the seller. So wala na siyang possessory lien, pero syempre meron pa rin siyang lien on the price. What else? If there is delivery, if the buyer or agent lawfully obtains possession of the goods, so buyer is already in possession. Ano pa ang possessory lien ng seller here? So ownership is transferred obviously because of the delivery to the buyer. So lien on the price, but not possessory lien. But obviously this will not apply if there is wrongful taking of the goods by the buyer, or meaning the seller did not consent to the taking. And also kung yung possession ng buyer is merely for examination, etc., hindi mo pa naman ibig sabihin ng sinusurrender yung possessory lien. What else? Waiver of the lien. The seller may lose his lien by express agreement to surrender it. So common sense class, meron dapat possessory lien ang seller pero ito ay sinurrender niya. So here, nawawala yung kanyang possessory lien. Anyway, kahit na mawala naman yung possessory lien, meron pa namang ibang remedies available to the seller. So, rights of seller to stop the goods in transit, or rights right of the seller to stop the goods in transito in 1530. So this will happen if the seller has already parted with possession of the goods. Kasi kung nasa possession pa niya, syempre, meron siyang possessory lien. Now, ngayon, in transit na, meaning papunta na siya sa buyer. Syempre, wala nang possessory lien yung unpaid seller. But he can exercise his right of stoppage in transito. So, seller will resume possession of the goods while they are in transit when the buyer becomes insolvent. So, the seller will obtain actual possession of the goods by giving notice of his claim to the carrier or other bailee in possession of the goods. So, unpaid seller exercising his right of stoppage in transito becomes entitled to the same rights to the goods as if hindi pa siya dineliver. So, as if he never parted with possession of the goods. So, what else? Take note here of the requisites for the exercise of the right of stoppage in transito. Seller is unpaid. Buyer must be insolvent. The goods must be in transit. Seller must actually take possession of the goods sold or give notice of his claim. Oy, papunta na yung goods sa carrier. Sabihin ng seller, oy, wag nyo nang i-deliver yan. So, seller must notify yung carrier or other person in possession of the goods. What else? Seller must surrender the negotiable document of title, if any, that is issued by the carrier or bailee. What else? Also, seller must bear the expenses of redelivery of the goods to him after the exercise of the right of stoppage in transit. So, anyway, a question, when are goods in transit? So, kailan siya considered to be in transit? So, obviously, after delivery to a carrier or other bailee and before the buyer or his agent takes delivery or possession of the goods. So, habang nasa carrier pa, considered in transit. What else? The goods are also in transit if they are rejected by the buyer. Here, the rejection is unjustifiable rejection. So, buyer unjustifiably refuses to receive the goods are still considered to be in transit, and the seller may exercise his right of stoppage in transito. So, what else? Goods are no longer in transit in 1531 if they are already delivered to the buyer or agent. What else? If the buyer or agent obtains possession of the goods before it arrives in the destination original fix, and if a carrier or bailee acknowledges that he is holding the goods not for the seller but for the buyer already. Take note also, if the carrier or bailee wrongfully refuses to deliver the goods to the buyer, yung carrier na to, yung mismong shipping company, wrongly refuses to deliver the goods to the buyer, the goods are no longer in transit. So take note of the term class attornment by the bailee. So in attornment by the bailee, remember the bailee is or carrier. The carrier originally is in possession of the goods on behalf of the buyer. Now, pagka nagkaroon ng attornment, the bailee recognizes that he no longer holds the goods for the seller but already for the buyer. So, yun ang attornment. So, ang effect ng attornment is to terminate yung right of the seller to exercise his right of stoppage in transit. Kasi nga, pagka na-deliver na sa carrier, tapos carrier acknowledges that he is holding the goods for the buyer, delivery to carrier is delivery to buyer. So, dahil nga hindi na siya in transit, na-deliver na siya sa buyer, the seller will lose the right to exercise his right to stoppage in transit. So, carrier, hindi rin siya pwedeng mag-refuse na deliver to the buyer or attorn as the buyer's agent. So, bawal din yun. What else? Delivery to a ship chartered by or owned by the buyer. So, if the ship is chartered by the buyer, remember, it does not mean, tapos doon mo deliver doon sa ship chartered by a buyer, meaning, inupahan, para lang madaling sabi, inupahan ng carrier does not make inupahan ng buyer does not make delivery to the carrier, delivery to the buyer. So, here there is a ship, tapos inupahan ng buyer. Pagka deliver yung goods nung carrier dun sa ship na yon, chartered by the buyer, it does not necessarily mean that is already delivery to the seller. Now, it will depend on the circumstances of a particular case, whether or not yung delivery to carrier is delivery to the ship, etc., chartered by the buyer is delivery to the buyer already. So, pagka delivery to buyer, goods are no longer in transit, obviously. Now, if the ship is owned by the buyer, obviously, delivery to the ship, etc., is delivery to the buyer. So, delivery to the vessel belonging to the buyer is delivery to the buyer. Now, also take note of partial delivery. So, partial delivery does not deprive the seller of the right to stop with respect to the remainder. So, na-deliver na yung part ng goods, pero meron pang part na in transit, pwede pa rin i-stop ng seller yan. What else? How to exercise the right of stoppage in transitu. Seller must obtain actual possession. So, intention to repossess the goods should be present. The seller should also give a notice of the claim. Kanino ibibigay notice of the claim? Person in actual possession of the goods, and to the principal of the person in actual possession of the goods. So, yung boss ng person who is actually in possession of the goods. Now, what are the effects if the right to stoppage in transitu is exercised? Goods are no longer in transit. Contract of carriage ends, and carrier now will become a bailee for the seller. So, hindi na di-deliver. So, yung carrier now should safely keep the goods on behalf or for the benefit of the seller. Now, carrier should not deliver anymore to the buyer or his agent. If he still delivers, carrier will be liable for damages. Carrier must redeliver to the seller according to his instructions. So, if there is an outstanding bill of lading or negotiable document of title, carrier or bailee has no obligation to deliver the goods to the seller hanggat hindi pinapakita ng seller yung document or yung negotiable document of title or bill of lading para makancel nila. Kasi pagka may lumitaw na bill of lading, nabigay na nila sa seller, tapos may lumitaw na bill of lading, syempre kailangan pa rin ng carrier to honor yung bill of lading in the hands of a third person. So, para wala na lang problema, syempre may nakiklaim pa, na-deliver na nga sa seller na yung nakiklaim na yun, mayroong siyang hawak na negotiable document of title or bill of lading. Syempre, magiging liable uli yung carrier. So, to prevent this from happening, kailangan bailee or carrier must deliver the goods to the seller when there is when the negotiable document of title has been surrendered. Now, 1533 is the special right of resale. So, in the special right of resale, yung seller who is in possession of the goods, so meron siyang possessory lien, or a seller who has exercised his right of stoppage in transitu, meaning in transit na pero in-stop niya, pinare-deliver niya sa kanya, or at some point yung goods nandun sa carrier, pwede niyang i-resell yung mga goods na yan para naman hindi nga siya malugi. So, what are the these are the requisites so that the special right of resale will be available. Buyer has defaulted in the payment of the price. Unpaid seller can exercise the right to resell only when he has a right of possessory lien or right of stoppage in transit. What else? Title to the goods has passed to the buyer. So, buyer na ang may-ari. Pero dahil hindi nga bayad yung seller, pwede niyang ibenta. Special right of resale nga ito eh. So, pwede niyang ibenta yung goods sa iba para nga naman mabayaran siya. Because the buyer, who is now actually the owner, does not want to pay him. Anong gagawin ng seller? Kawawa naman. So, resale is allowable. These are the grounds if the goods are perishable. syempre mabubulok na nga, dineliver sa buyer, ayaw naman bayaran, tapos nandun pa sa seller kasi may possessory lien siya, or in-exercise niya yung right of stoppage in transito niya, tapos hindi pa siya bayad, nabubulok na. So, anong gagawin mo if you are the seller? Resell it to other people. If there is an express stipulation that this is allowed, common sense ito. And remember, if there is unreasonable default in the payment of the price. So, hindi naman perishable yung goods, pero sobrang tagal na, hindi pa rin binabayaran ng ng buyer yung goods. So, remember, there is a right but not a duty to resell. So, bibigyan ng right ang seller to resell, but it does not impose upon him the duty to resell. So, yung right of resale, remember, is not applicable if title to the goods has not yet passed to the buyer. So, kailangan nag-pass na sa buyer so that the seller can avail of the special right of resale under, anong article to? 1533. Now, deficiency or excess in the price. So, nung binenta yung goods which are perishable, sabihin na number 1 ang example natin, there is a deficiency in the price. So, resale price is lower than original selling price. So, remember that the deficiency in the price may be obtained from the buyer as damages. Any excess naman will go to the seller. Take note that notice of resale is not essential, meaning it's not essential to inform the buyer that you are reselling the goods. So, it does not affect the validity of the resale. So, except ito, syempre, if the basis of the resale is the perishable nature of the goods or where the right to resell is reserved, the failure to give notice shall be if the basis of the resale pala is not the perishable nature of the goods or where the right to resell is reserved, the failure to give notice is relevant to answer the question whether the buyer has been in default for an unreasonable amount of time. So remember, class resale is available when there is an express stipulation or kung nagkaroon ng unreasonable default in the payment of the price. Paano natin malalaman kung unreasonable na yung default? So, to determine that, syempre, it depends on the notice that is given. So, what is reasonable will vary according to the circumstances of the case. Also, likewise essential to the validity of resale that notice, not likewise essential, hindi rin kailangan na notice of the time and place of the resale be given by the seller to the original buyer. Pero prudent daw na magbigay ng notice. So, usually yung notice may be important evidence in regard to the fairness of the sale. So anyway, manner of resale, hindi naman kailangan na formal auction. So the law is satisfied with a fair sale made in good faith according to the established business methods with no attempt to take advantage of the vendee. So kailangan lang, ang requirement lang, seller is required to exercise reasonable care and judgment in making a resale, but he cannot directly or indirectly buy the goods. So also take note that the seller may resell the goods in a public or in a private sale. Yung auction is not required. Kasi syempre mamaya magkano lang yun, tapos papa-auction pa, diba? Kakahiya naman sa buyer na hindi nagbabayad. What else? Effects of resale. Seller shall not be liable to the original buyer upon the contract of sale for any profit made by such resale. So kung mas mataas ang value ng resale, hindi na kailangang ibigay ng seller yan. Number 2, seller may recover damages in case of breach of contract and also in case of deficiency, and the buyer in the resale acquires good title as against the original buyer. Now, the special right to rescind in 1534, syempre, merong possessory lien ang seller. Meron siyang right of stoppage in transito. So, nasa kanya yung goods or na-stop niya in transit. So, remember here that the seller is given a special right to rescind yung sale. This is available when the buyer has defaulted in the payment of the price, common sense. The seller has a lien or has stopped the goods in transit, and title to the goods has passed to the buyer. Now, the grounds for the right to rescind are, number one, if it is expressly reserved. In case the buyer is in default, and if the buyer delays payment for the price for an unreasonable time. So, paano ba mag-rescind? Sabi sa 1534, give notice to the buyer of the intention to rescind. Do an overt act manifesting an intention to rescind. So, hindi naman talaga necessary na yung overt act be communicated to the buyer. But the giving or failure to give notice shall be relevant in any issue involving the question of whether or not the buyer has been in default for an unreasonable time before the right of rescission was asserted. So, the effects of rescission, obviously, the seller is not liable to the buyer upon the contract of sale. So, wala nang contract of sale, hindi na liable ang seller to deliver. What else? Seller may also recover from the buyer damages because of the breach of the contract of sale, and the seller will resume ownership of the goods. Now, question, paano kaya kung naibenta na rin ng buyer yung goods? So, yun ang question. So, even before the goods are delivered to him, probably the buyer has already sold the goods. So, what are the rules? General rule, the unpaid seller's right of lien or stoppage in transitu remains even if the buyer has sold or otherwise disposed of the goods. Nandun pa rin yung right of lien, right of stoppage in transitu. Except, number 1, seller has given consent to the sale, and when a negotiable document of title representing the goods has been negotiated to a purchaser for value and in good faith. So, syempre, pagka negotiable document of title, kailangan, kumbaga parang mawawala na yung right of stoppage in transitu and yung right of yung possessory lien. So, yun ang tandaan natin. What else? 1536, right of vendee to withhold delivery in case of sale on credit. So, sale on credit, again, buyer is given a time to pay. So, if the vendee was given benefit of the period, the vendor may not be compelled to make delivery if the vendee already lost yung right to make use of the term under 1198. So, tandaan ninyo, pagka merong benefit of the period ang vendee, meaning sale on credit siya, pwedeng i-deliver na yung goods sa buyer without the buyer paying for it. So, kahit di pa bayad, pwede nang i-deliver ng kailangan ng pwedeng naibigay na yung goods sa seller ay sa buyer. Pero remember class here na if the vendee even prior to the delivery has already lost yung right to make use the period under 1198, yung seller may refuse to deliver. So remember, the vendee will lose the benefit of the period if the vendee becomes insolvent unless meron siyang guarantees or security given for the debt. If the buyer does not furnish yung guarantees which he has promised to the seller. What else? Buyer impairs yung guarantees or securities or they disappear by a fortuitous event. Pinag-aralan natin to sa Oblicon class if you do not remember. If the buyer violates any undertaking in consideration of which the seller agreed to a period, and if the buyer attempts to escape or abscond. So, in addition to that, ang haba talaga ng chapter na to, in 1537, other rules regarding delivery. So, obviously, yung terminologies nyo, please take note of the term accessions and accessories, which we have already studied. So, the Article 1537 impliedly reiterates yung duty of the seller to preserve. So, kasi sabi dun sa 1537, the thing sold and its accessions and accessories must be in the condition in which they were upon the perfection of the contract. So, kailangang i-preserve mo yan. So, anyway, besides that, 1537 talks about the duty to deliver accessions and accessories even if they are not mentioned in the contract. So, what else? Kailangan to specifically remove accessions and accessories, there must be an express stipulation. Duty to deliver fruits also, syempre kasama din yan. The vendee is entitled to the fruits from the time the obligation to deliver it arises. So, obligation to deliver arises upon the perfection of the contract of sale. So, yan. So, anyway, usually ang example dito, seller sold his horse tapos to the buyer for something price, tapos walang date or condition for delivery, but while still in the possession of the seller, the horse gives birth to a colt. Yung nagkaroon siya ng baby, in short. Syempre, sino ang may right sa colt na yan? So obviously, if the buyer has paid the price, the buyer will have a right to the colt. Now also if buyer has not yet paid the price, it is the seller who will have a right to the colt if the horse has not been delivered yet. So anyway, vendee is not entitled when the rule provided in 1537 is modified by agreement. So because of agreement, the vendee is not entitled to the fruits kasi yun ang napag-usapan, common sense. If the vendee receives the contract of sale, instead of exacting fulfillment, he is entitled to only to damages, etc., but not to fruits of the thing sold. Siyempre, kinansel na niya. Nakabigay pa sa kanya yung fruits, di ba? What else? Other rules. In a contract of promise to sell, the vendee is not entitled to the fruits. So, promise to sell pa lang naman kasi. So, pagka promise to sell, promise to buy or sell, ang right lang talaga ng parties dyan is to demand fulfillment of the contract. Wala pa naman talagang technically sale dyan. So, 1538 talks about yung effects of loss, deterioration, or improvement of the thing after perfection of the contract but before delivery. This is in consonance with the rules in 1189 if I'm not mistaken. So, yan. So, reiterates the rules that from the time of perfection to delivery, risk is borne by the buyer in accordance with 1480. So, in 1480 and 1538, ang sabi talaga doon malinaw, loss will be suffered by the buyer pending delivery. So, in 1504, this is a contradiction. But remember, ang makakaayos lang talaga dyan is legislation. So, in 1189, so remember class na siguro ang pwede kung diniscuss na natin to. So, if the thing is lost through the fault of the through a fortuitous event, loss, deterioration, buyer object is lost before object is lost by a fortuitous event. Remember class, the obligation of the seller is extinguished. Subject to qualifications. What else also? What about if the object is destroyed by the seller after perfection but before delivery? Remember class here that seller is liable for damages. What else if the thing deteriorates through the fault of the seller? Remember class, buyer can choose between fulfillment and rescission with damages in either cases. So, i-apply nyo lang yung 1189 doon sa ating rules. So, in what else? 1539, this is a sale of a real property by unit of measure or number. So, the first rule here, remember class, is that the entire area stated in the contract must be delivered. So, remember in a sale of real estate by a unit of measure or property, there should be a statement of the area. So, let us say 1,000 square meters. That is a statement of the area. Now, yung rate of a certain price per unit of measure or number ibig sabihin niya na, for example, 10,000 per square meter. So, 10,000 is the rate of a certain price. Tapos yung per unit per square meter, unit of measure or number. So, kailangan dun sa contract, meron siyang statement of area and also yung rate of a certain price per unit of measure or number. So, anyway, here, remember that the vendor must deliver the entire property agreed upon. And also, yung immovable must be of the quality specified in the contract. So, anyway, what if class, the entire area cannot be delivered by the seller? So, if the entire area cannot be delivered by the seller, remember class, as far as the buyer is concerned, the object or the real property has not been delivered. So, the buyer here has a choice to rescind yung contract, or also the buyer can enforce the contract pero merong decrease in the price. So, again, same example, 1,000 square meter land at the rate of 10,000 per square meter, but it turns out that the land is only 800 square meters. So, yung additional 200 square meters should be given by the seller actually if the buyer demands yung delivery ng 200 square meters na deficiency. But also, if hindi kayang gawin ng seller ito, yung buyer has a choice to rescind yung contract of sale. However, class, remember also that pwede rin namang piliin ng buyer yung corresponding decrease in the price of the sale. So, imbis na ang babayaran is 10 million, ang babayaran na lamang is 8 million for 800 square meters. Now, rescission is not a right that is available all the time. So, remember class, when the buyer will be entitled to rescind only if it corresponds with the following requisites. Lock-in area is at least 1/10. At least 1/10 than that stated or stipulated. So, yung 1/10 should be based on the area stipulated in the contract. So, kung halimbawa 1,000 square meters, tapos ang locking area is 99 square meters and below, the right to rescind is not available kasi dapat at least 1/10 siya. So, 1/10 is 100 square meters. Dapat yun ang deficiency before the right to rescind is available to the buyer. What else? Deficiency, basing doon sa quality, exceeds 1/10 of the price agreed upon. So, yung quality na pag-agrihan nyo, ito, tapos yung quality ng lupa, ganito lang. Tapos, remember class na kung titingnan natin yung value, magkano ba yung loss ng value? So, if it exceeds 1/10 of the price agreed upon, so remember, the buyer has a right to rescind yung sale. Obviously, buyer will have a right to rescind also if kung alam lang niya na mas maliit yung lupa, irrespective of the extent of the deficiency and also irrespective of the quality of the land, hindi niya sana bibilhin. Kung alam lang niya na ganitong klase lang na lupa yan, kung alam niya ganito lang ang area niyan, hindi niya binili. Let's say, kailangan niya 1,000 square meters talaga, period. Kung alam lang ng 950 yan, hindi niya bibilhin. 800 yan, hindi niya bibilhin. So, again here, remember, the vendee will have a right to rescind. So, regardless of quality, regardless of lack of area, extent of lack of area. So, remember, paano naman kung mas malaki? O, di ba? Kanina mas maliit, ngayon mas malaki na. So, area or number in the immovable greater than that stipulated in the contract, the vendee may accept the area included in the contract and reject the rest. So, let us say, class, ano bang example nito? Buyer buys from a seller a parcel of land supposed to be 1,000 square meters at the rate again of 10,000 per square meters, 10,000 per square meter. So, but again, yung land is, let us say, 1,500 square meters. So, itong si buyer can accept yung 1,000 square meters and pay 10 million for it, if I'm not mistaken. Syempre, math yan. And also, now, buyer can reject the rest. So, buyer can reject yung 500 square meters. But here, also, tandaan nyo na buyer can also accept the whole of the land. but he will make himself liable for the price of the same at contract rate. So buyer can also accept yung 1,500 square meters and buy 15 and pay 15 million for it. But in no case, in number 1 and number 2, is the buyer allowed to rescind the sale. Take note also that the rules in 1539 and 40 are applicable even to judicial sales. Now, 1542 talks about a sale for a lump sum or a cuerpo cierto or por precio alzado. So, lump sum, yung kabuuan, binibenta. Kasi yung mga sale kanina in 1539 and 1540, sale for a certain price per unit of measure. But here, hindi na natin titignan yung area. Basta itong buo na to. Kasi kanina, 10,000 per square meter, di ba? Ito, basta itong lupa na to, 1 million. Ganyan. Basta itong lupa na to, 10 million. So, yun ang lump sum sale. Not at a certain rate or certain price per unit of measure. Now, obviously, you have to deliver all the land included in the boundaries. So, if you buy land, meron talaga kasing description yan dun sa deed of sale. Meron din description yan sa title. So, anyway, sa deed of sale may description. So, include yung buong area, deliver to buyer, yung all land included in the boundaries. So, if it turns out na, let us say, dun sa contract, area is stated to be 1,000 square meters. So, yun ang akala ng buyer. Pero noong deliver ng seller yan, it turns out that it is 1,500 square meters. Anyway, yung buong 1,500 square meters na yun is within the boundary. Remember, class, that yung seller has to deliver yung buong 1,500 square meters. So anyway, what if it turns out na nakalagay sa contract of sale 1,000 square meters siya, tapos nilagay yung boundaries, tapos within that boundary, yun pala 800 square meters lang yung area. So anyway, remember, class, the seller has to deliver all of the land included in the boundaries. So kung kulang siya, greater area or lesser area, this is immaterial as long as the seller delivers all the land included in the boundary. And there shall be no increase or decrease in the price. So, yun ang tandaan nyo. Kung may extra, bibigay pa rin ng seller. Kung may kulang, the buyer cannot claim yung deficiency and also cannot claim a reduction in the price. So, ano ba yan? So, anyway, what else? So, remember also that here, there is, if it turns out that the land is lesser in area, the buyer has no right to rescind and no right to pay a reduced price. Walang right to rescind, walang right to pay a reduced price. What else? If the seller fails to deliver yung all land included in the boundaries, there is no faithful compliance in the with the contract. So, vendor shall suffer a reduction in the price in proportion to what is lacking in the area or number unless the contract is rescinded because the vendee does not consent to the failure to deliver what has been stipulated. So, if it was same problem, if it was 1,000 square meters, nakalagay yung boundaries sa contract. If it was discovered that the land really contains 1,500 square meters within the boundaries and B is not able to deliver yung extra 500 square meters kasi 1,000 lang ang nakalagay sa contract. Pero within the boundaries, it is 1,500. So anyway, seller cannot deliver yung extra 500 square meters. So the rights of the buyer are, buyer may rescind the contract because the seller failed to deliver yung extra na nandun pa within the boundaries, or the buyer can pay a reduced proportional price. So, remember, 2/3 of the original price because ang makukuha lang talaga niya is 2/3 of the land included within the boundaries. Siyempre, di ba, 1,000 square meters nga naman talaga yun, pero 1,500 kasi ang nakalagay sa boundaries. So, anyway, what else? Prescription of actions. So, prescription of actions, based in 1539 and 1342 for rescission of contract or proportionate action quanti minoris ang tawag sa proportionate reduction of the price. Must be brought within 6 months from the counted from the day of delivery. Quanti minoris, Q-U-A-N-T-I-M-I-N-O-R-I-S. So, action quanti minoris. What else? Double sales, 1544. So, please take note of the definition of a purchaser in good faith. So, a person who buys a property without notice that some other person has a right to the property or interest in the property, and the purchaser in good faith pays a full and fair price for the object or good. So, before he has notice of the claim or interest of some other person in the property. So, in all the rules which I will mention, there must be a good faith. Otherwise, yung order of preference will not apply. So, article will not apply also if the double sale is not made by the same person. So, here, same person sells the same thing to two different persons. So, article also applies to a double donation. And also, in case the sale is made by the principal, tapos another sale is made by the agent of the principal concerning the same property. So, sale by the principal, different person, sale by the agent, different person, but concerning the same property. So, what else? Okay, so anyway, the rules of preference, personal property, possessor in good faith. So, the first to take possession of the personal property in good faith is entitled to, is preferred over yung other buyers. So, maraming bumili nitong object na to. So, let us say a car. So, binenta ni A kay B, binenta ni A kay C. But remember, C took possession first. So, when C took possession, he is in good faith. He is not aware of the sale to B. So, remember, C being a possessor in good faith, he is entitled to the car. So, anyway, what else? In case naman of real property, the first to register in good faith. So, preference will be given to the first to register his land, the land to his name in good faith, over another vendee who has not registered his title. Even if yung hindi nag-register ay actually in possession of the immovable. So, ako si A, lagi ako si A, binenta ko kay B yung parcel of land, binenta ko uli kay C yung same parcel of land. Si C, pumwesto ka agad. Pagkapwesto ni C, ito namang si A, ito namang si B, ako pala si A, ito namang si B, wala siyang kaalam-alam na si C ay nakapwesto na pala. Tapos itong si A ay registers the land to his name. Saan ba nire-register yung land? Yung sale ng land sa Registry of Deeds, for which mag-i-issue tayo ng title. Anyway, yung ating paraan para magpatitulo ng lupa is called the torrents system. So, registration yan. So, all lands covered by a title is covered by the torrent system, obviously. So, anyway, yun sa example ko nga, B registers the land. When B, the sale, when B registered the sale, B is not aware that there is a sale to C. B is not even aware that C already occupied the land. So, who will be preferred? Remember, class, B will be preferred. Baliktarin natin. So, A sells the land to B, then sells the same land to C. B immediately takes possession. Ito namang si C, who is the second buyer, unknown sa kanya yung transaction with B. Wala siyang kaalam-alam talaga that B already bought the land, B is already occupying the land. But itong si C, after the sale, immediately transferred the same to him. Transferred the land to himself. Question, who is entitled? Remember, class, C is entitled. So, it does not matter kung nauna ka or nahuli ka. Basta ang point dyan is ma-register mo in good faith yung iyong sale. Basta ikaw ang naunang mag-register, tapos hindi mo alam na merong ibang, lalong-lalo kung ikaw yung second buyer. Mamaya i-qualify ko yan. Merong ibang sale, remember, you are entitled to, meron kang preference. So, let us take for example, si A, binenta niya kay buyer 1. Tapos, after binenta kay buyer 1, binenta kay buyer 2, same parcel of land. So, anyway, itong si buyer 1, when he bought it, obviously, good faith yan. Kasi, wala pa namang sale kay buyer 2. Now, itong si buyer 2, nung binili niya yung parcel of land, good faith din siya. He is not aware na mayroong sale kay buyer 1. So anyway, let us say walang tao in possession of the land. Let's just say for example. So anyway, itong si buyer 2, bigla, he discovered the sale to buyer 1. So nalaman ni buyer 2 that there is a sale to buyer 1. Ngayon, itong si buyer 2, dahil alam na nga niya na may naunang sale at siya si buyer 2, agad-agad tumakbo siya sa registry of deeds, pinaregister niya yung kanyang sale. So, remember, sale is registered in the name of buyer 2, not registered in the name of buyer 1. Nobody is in possession. Who is preferred? Remember, buyer 1 is preferred. Bakit? Kasi yung registration ni buyer 2 is not in good faith. So, yung knowledge kasi ni buyer 2 of the sale to buyer 1 places buyer 2 in bad faith. So, yun ang tandaan natin. Ibahin natin yung problem. Sige. A, seller sells to buyer 1 and then sells to buyer 2. So, obviously, buyer 1, when he bought the property, he is in good faith. Buyer 2, let us say, when he bought the property, he is in good faith as well. Later on, si buyer 1, nalaman niya yung sale kay buyer 2. Nung nalaman ni buyer 1 yung sale kay buyer 2, immediately, buyer 1 registered the sale to himself, to his name. So, question, nobody is in possession. Question, who is preferred, buyer 1 or buyer 2? Remember, class, sasabihin nyo yan, buyer 2, kasi bad faith yung registration ni buyer 1. Hindi, remember, class, buyer 1 is preferred or entitled to the land. Bakit? Kasi buyer 1 siya yung nauna. Tapos, yung, nung binili niya yon, good faith siya. So, yun ang tandaan natin. Nung at the time of sale, buyer 1 is in good faith. Yung subsequent knowledge niya is immaterial. As long as nung binili niya, and he is the first buyer, remember, buyer 1 is preferred over buyer 2. So, isipin nyo na lang ganito yan. Buyer 1 and buyer 2, nasa race sila. Unahan silang mag-register. Talaga, sa totoo lang. Di ba, unang mag-register is given more credit or preference. Now, itong si buyer 1, pagka nalaman niyang ka-racing niya or ka-kompetensya niya si buyer 2, okay lang yan. So, kung nauna siyang mag-register, walang problema. Even if buyer 1 has knowledge na meron siyang ka-racing, may kakompetensya siya. Yan. Now, remember, for buyer 2, the rules are different. Kasi nga, buyer 2 na siya eh. Now, si buyer 2, dapat habang tumatakbo siya, hindi niya alam na meron siyang kakompetensya. Hindi niya alam na meron siyang ka-racing. Remember, the moment na malaman ni buyer 2 na meron siyang kakompetensya, the moment na malaman ni buyer 2 na meron siyang ka-racing dito, it's a race. But if buyer 2 knows that there is a race, nalaman niya na may race pala, remember, buyer 2 is placed in bad faith. So, swerte ka kung buyer 1 ka. Na pagka nalaman mo na may race pala, ay may race, tapos may kalaban pala, tapos tumakbo ka ng mabilis. Kasi nga, alam mo na may kalaban. First to register, okay, walang problema. Kahit na alam mo na mayroong subsequent sale to buyer 2. Now, ikaw si buyer 2, dapat wala kang malam. You should not know that you are running a race. The moment that you know that there is a race to register, the moment you know that meron kang competition, the moment you know that there are other racers or merong buyer 1, you are already placed in bad faith. So anyway, mere registration is not enough. Good faith must also concur. So, acquisition and good faith registration in good faith. Also, conveyance has been properly recorded. Such record is constructive notice to the whole world of its contents, all interest, legal and equitable included therein. So, governing principle here is, remember, prius tempore potior hure, first in time, stronger in right. So, remember, knowledge by the first buyer of the second sale cannot defeat the first buyer's right or good faith. Except if yung second buyer registers yung sale ahead of the first buyer and the second buyer is in good faith. So, pero remember again, knowledge obtained by the second buyer of the first sale defeats yung kanyang rights even if he is the first to register, because yung registration niya is tainted with bad faith. So, second buyer must show continuing good faith, innocence, lack of knowledge, etc. of the first sale until ma-register niya yung kanyang sale. So, registration will require actual recording. So, what else? Possessor in good faith is preferred. So, possession here is actual or constructive possession since the law makes no distinction. So, kung nobody registered, the possessor in good faith is preferred. Now, what if there is no registration, no possessor in good faith? The person who can present the oldest title, like a deed of sale. Yan. Hindi ni-register yung deed of sale. If the person can present yung oldest title, oldest deed of sale, remember, he will be preferred in the absence of registration, in the absence also of possession. So anyway, that ends yung ating lecture in Chapter 4, Section 2. Please stand by for Section 3, another long lecture, pero hindi kasing haba nito. So anyway, class, sana napagtiyagaan ninyo. And please try to study before our class. Not required to watch this, obviously, but you are required, however, to read your book. So anyway, thank you, class, and good night.